Welcome, everyone, to this Monday, April 26, 2010 edition of Money, Banking, and Trust by Moving Titles and Commerce. Welcome to the Trust Ambassador call on Monday night here. I've been going through Black's Law, 8th edition, and I've come across some interesting definitions.
Out of what book? What edition? 8th edition, you said?
Yes, the 8th edition's Black's. I'm going to go over this on Saturday somewhat. The definition of give and the definition of merge. Give was to voluntarily transfer property to another without compensation. And that would be, consideration would be, say, for example, my interest. And also the definition of gift was the same exact definition of give, which was voluntary transfer of property to another without compensation. And then number two, they had a thing so transferred. Merger was a definition that really caught my mind because it said that the merger was the act or the instance of combining or uniting in two under contracts. It was the substitution of a superior form of contract for the inferior form. So when the written contract supersedes all oral agreements and prior understanding. And then they had a quote from William R. Anson's Principles of Law of Contracts. Arthur L. Coburn did the editing, 3rd edition, American edition, of 1919, where they, quote, said that when two parties have made a simple contract for any purpose and afterwards have entered into an identical engagement by deed, the simple contract is merged in the deed and becomes extinct. And this extinction of the lesser in the higher security, like the extinction of the lesser in the greater interest in lands, is called a merger. So this, after entering into the identical engagement by the deed, and the deed, I liken that to the deed of trust or the confidence. And a simple contract is merged in the deed and becomes extinct. This extinction of the lesser and the higher security, and Lewin talks about the security of the pledge or the confidence, which would be the trust, like the extinction of the lesser and the greater interest in the lands is called a merger. So that security of the pledge, trust, or the confidence. Now, engagement is contract or agreement involving mutual promise. And promise, again, is really a bond, and a bond is my pledge or my security, which, again, is the trust. So now I'm going to go to termination of employment under Black's Law. I don't have it written down, so I'll have to turn to it. Okay, termination was the act of ending something, extinguishment. So they're talking about, under the merger definition, there's something that when the simple contract is merged in the deed, it becomes extinct or extinguished or extinguishment. So termination, the act of something, extinguishment, termination of the partnership by winding up its affairs. And then to terminate, to put an end, bring to an end, or to end, to conclude. And under termination, there is an additional one, termination of employment, the complete severance of an employer-employee relationship, cases under master and servant. So master and servant, here we are, feudal times again. So see corpus juris secundum apprentices, and also section 10 were employer-employee relationships. And here we are talking about relationships. You know, be constantly on relationships you are forming on a moment-by-moment basis, especially upon on the moment of signing? Are you being tricked into giving your voluntary transfer to another party? Like when the judge asks you, what is your name? Who are you? He's tricking you to give a transfer of your name for compensation. So termination of process. Termination of proceedings also. Administrative action to end a person or entity status or relationship. So, for example, the International Banking Act authorizes the International Banking Board to institute a termination process when a foreign bank or its U.S. agency or branch is convicted of money laundering under 12 U.S.C.A. Section 3105E. Maybe we ought to get them for money laundering. They took my money. What did they do with it? I want my note back. Surrender the note. So let's look up trespass. Trespass, Black's Law. Trespass, an unlawful act committed against a person or property of another, a special wrongfully entry of another's real property. Number 2, add common law in action for injuries resulting from an unlawful act of this kind. There is a lot here under the trespass. They're quoting from the textbook of the Law on Torts, where they're saying the familiar legend on notice boards, trespassers will be prosecuted, implies it is a crime, but this may easily be dismissed as a wooden lie. Yet, in times past, the idea was correct, for trespass of any sort was punishable by a fine and imprisonment, as well as a redressable by an action for damages. And actually it was not until 1694 that the punitive element disappeared, although it had faded into obsolescence long before that date. But nowadays, trespass is never a crime except under special statutes. Special statutes. There's those special things that we were talking about, I think, a week or so ago, where everything really the real man does is a special connotation. It's a special deposit. It's by special statute. It's by special this, special that. And if we look up at Black's Law definition of special, it goes through a whole rendition from A to Z of things that are special. So under the special statutes, which make it punishable, and continuing on the next paragraph, the term trespass has been used by lawyers and laymen in 3 senses of varying degrees of generality. One of its widest and original significance includes any wrongful act, any infringement or transgression of the rule of right. This use is common in the authorized version of and was presumably familiar with that version was first published, but it never obtained recognition in the technical language of the law and is now archaic even in popular speech. And 2, in a second narrow signification, its true sense, legal true sense, is the term means any legal wrong for which the appropriate remedy was a writ of trespass, and any direct or forcible injury to a person, land, or cattle. And 3, the third and narrowest meaning of the term is that in which, in accordance with popular speech, it is limited to one particular kind of trespass in the second sense, the tort of trespass to land, where a trespass, a quorum clausum frigat. And the next paragraph, before the word misdemeanor became well established, the old writers tended to use the word trespass to indicate an offense below the grade of felony, and it was used at times by Blackstone for this purpose, as in the phrase treason, felony, or trespass.
Christian.
Yeah, Pete, go ahead.
Hi. I found one in Black's Law called spoliation. I don't know if you're aware of that term.
Yeah, that's with that special cream and the hair's on.
Sorry?
Go ahead.
It says, spoliation, the intentional destruction, mutilation, alteration, or concealment of evidence, usually a document. If proved, spoliation may be used to establish that the evidence was unfavourable to the party responsible. And it's got cases of evidence, federal civil procedure, CJS discovery, and then it says, the seizure of personal or real property by violent means, the act of pillaging, and number 3, the taking of a benefit property belonging to another. So, if you've got a beneficial interest in something, and then someone's denying you that beneficial interest, I would consider that someone's taking the benefit property belonging to you, and therefore is spoliating.
Yeah.
It's just a small section in Black's Law 8. Just thought it was kind of similar to the trespass.
Okay. So now trust account. If we're going to have a trust deposit, I guess we're going to put it in a trust account. Trust account, Black's Law says, see client trust account. See client trust account. Talks about the attorneys having the accounts there. In camera. In camera. Says it's also in chambers. The judge's private chambers, and the key operative word I think is private. Judge's private chambers in courtroom with all spectators excluded. So there's an exclusion there. No spectators. Again, it's private connotation. And also 3, when taken when court is not in session. And it is also termed in reference to the opinion of one judge in chambers. And right below that is in-camera inspection. In-camera inspection, a trial judge's private consideration of evidence. Private consideration of evidence. Also in-camera proceeding, see proceeding. We could go to open court. Open court. Open court. Black's Law says a court that is in session, presided over by a judge, attended by the parties and their attorneys, and engaged, is that word, engaged in judicial business. Open court usually refers to the proceeding in which formal entries are made on a record. The term is distinguished from a court that is a hearing evidence in camera. So read that one again. The term is distinguished from a court that is hearing evidence in camera, or from a judge that is exercising merely magisterial powers. To a court session in the public is free to be attended, and most state constitutions have open court provisions guaranteeing the public right to attend trials. Okay, so I think words are switches that complete the circuit so that the current flows, or the currency flows. Words make up the verbiage for a trust indenture. Our words determine the venue or the jurisdiction we operate in, and our words determine the type of estate we hold our property in. If we use debtor-creditor wording, our estates would be held in the jurisdiction of debtor-creditor. If we use the trust words or vocabulary along with knowing and understanding the debtor-creditor words, we can control the jurisdiction and our estates simultaneously. Private, non-negotiable, no trespassing, special this, special that, example, special deposit, close, we didn't look that one up, but we should probably look that one up, and similar words are private trust words, which mean we manifest the private by saying and doing something as a protective order or give or grant the privateness of the matter. It's privileged, it's private, it's confidential, it's in a reliance of confidence, a trust, and only enforceable under a trust and not debtor-creditor. So when the judge or the cop asks you, let me see your driver's license, your registration, and your insurance, or they're asking you to give them something. And give, by definition, was the voluntary transfer of property to another without compensation. So how am I going to block that? What is your name? What is your name, sir? How are you going to block that? What are you going to say when the judge says, next matter, and they read your name, so-and-so, your name? And you stand up, here, I'm here for that matter. And the judge makes the claim. Who are you? What's your name? And he's taking the jurisdiction by tricking you to give or transfer your name without compensation. But only a beneficiary has the right to take, as we've discovered in Lewin, because only the beneficiary has the right to the use. The trustee has the duty to the uses. Only the beneficiary has the right to take from the trustee. So what is your counterclaim going to be? Why are you taking my name? Or are you taking my name? The judge may say yes. What's your comeback? What right do you have to take my name? Or what type of relationship do we have here? Are you the beneficiary? Are you claiming a trust? The judge is going to probably say, no, I'm not claiming a trust. I don't see a trust. And then I claim I am the beneficiary. And who are you? And what right do you have to take my name? Just some little things to think about there. But what if I set up in my name Christian Walters in confidence for future return with my interest? And how about if I sign grantor or some under trust, and or at least an ellipsis, and then later on I come in with the counterclaim, execute the expression of the trust, which is under equity, and bingo, claim a trust, prove a trust, which is really the deed of trust, and a deed, remember, is an act written down. That's all a deed is. Then give them notice with the UCC and the county, claim the trust and correct the misconstruement of the debtor-creditor, which is the statutory, then go after the interest, which is the proceeds therefrom of your signature, and the bonds that were created from it, and liquidate the bonds as the counterclaim. And you could go after treble damages on top of that. under 8-507 UCC as an entitlement holder, issue an entitlement order. So, coming into court, going to have to plead special matters. There's that word special again. In particular, I checked it out in federal. I couldn't see it in federal, but in Florida here, it's 1.120, pleading special matters, under 8, capacity, where it is not necessary to avert you have a party to sue or be sued, the authority of the party to sue or be sued in a represented capacity, or the legal existence of an organized association. There's that word association. If you don't know that one, better look that one up. Association of persons that is made a party, except to the extent required to show the jurisdiction of the courts. So when a party desires to raise an issue as to the legal existence of any party, capacity of a party to sue or be sued, or the authority of a party to sue or be sued in a represented capacity, that party shall do so by specific negative averment, which shall include such supporting particulars as are particularly within the pleader's knowledge. And now under the author's comments, 1967, it says that Rule 1.120 is identical to formal Rule 1.9 in 1954, Rules of Civil Procedure, and almost identical to Federal Rule 9. As such, first Barron and Holtzoff, Federal Practice and Procedure Rules Edition, which is West 1960, should be consulted as a most helpful guide of construction of the similar federal rule. Does anybody have that available out there? Anyway, continuing on. Next paragraph. Fraud, mistake, breach of trust. Breach of trust. Willful default or undue influence cannot be pleaded generally. Cannot be pleaded generally. That's breach of trust. Cannot be pleaded generally. These defenses must be pleaded specifically as the circumstances may permit, but malice, intent, knowledge, or mental attitude may be averred generally. But anyway, breach of trust. Got to plead special matters. Special, the key word, special. Anytime you see the word special, your eyes and ears better perk up, because it's talking about the real man's substantive rights that they're hiding by this trick of special. Anyway, that'll maybe set the venue tonight, so press star 6, state your name, where you're from. Eric, you on? JC, you on?
Yes, Christian.
Yes. Who's this?
This is Bill from New Jersey. A question about when the judge asks you for your name. Suppose he says, state your name for the record, sir.
Well, Your Honor, you're taking my name.
Okay. No, just state your name for the record, sir. I'm not taking, just state your name for the record.
Well, the point is, you know, they're trying to get you to volunteer for you to give it. Because when you give it voluntarily, then you transferred it.
Exactly.
Yeah. So, you know, your name is a piece of property, which is trust res. And it's what I was kind of leading to was the protective amount, which is this protective order and things that's really protective, is that you're granting it to be private. And you need to do something to, some kind of act to manifest its privacy. Either an objection or a protective order you need to put on it or something. So that it can't be disclosed, so that you don't breach your own trust.
Right. You know, we had a conversation about Friday or Saturday about protective order. I'm curious, how would the Ninth Amendment play into that? Because that seems to be rights are not specified. Would that have any Would that be helpful for us?
Yeah, we were going through Black's Law today, and we came up with the 9th and 10th Amendment, which contains the privacy things. Now, keep in mind that Constitution is not yours. They swore an allegiance to that Constitution. They swore an oath. If they're not protecting your privacy rights in that Constitution, which they swore an oath to, now they're operating in bad faith, which is a breach of the public trust.
Right. So then, when we're part of the special trust words or terms, to help us, we were talking about the possibility of not getting a protective order, or the judge not acknowledging the protective order.
Well, I think we're asking them for too much. I think we should be giving the orders ourselves.
Okay, but still to do that, then we'd say pursuant to the 9th Amendment. Is that what you're saying?
Well, you could come on with something colorful. Yeah, I like that. They swore an oath to it. It's really private, so I want to keep it private. And I really don't want to cause you to breach the public trust by making my private trade secret information public. And therefore, I'm going to put an injunction against you so that you don't disclose it. So you don't trespass.
Right. Right. The 5th Amendment, you can't testify against yourself.
Christian?
Yeah.
Under Rule 9, number 2, it says raising those issues. To raise any of those issues, a party must do so by a specific denial, which must state any supporting facts that are particular within the party's knowledge. In other words, if you know the difference and you have a denial that you bring up, there's your response when he asks for your name.
Okay.
Christian? That's number 2 under Rule 9.
Okay, go ahead, Jacob.
Well, I was in court the other day on a traffic matter, and they
Well, you're supposed to stay out of court now.
Huh?
You're supposed to stay out of court now.
Well, I know, but I stood up and he tried to do something to me, and I told him, hey, look, I can't give you my name. I can't go into your court. I can't swear because I'm a Hebrew priest. And I said, and I just said, go out to the desk, give him $100. I'm going to leave right now. He said, go ahead.
What was the fine?
It was $106 for a stop sign.
Oh, so you paid the fine anyway.
The police officer was there for the trial. It was the second time they had scheduled it. I didn't show up for the first time. So I showed up the second time, and then I just told him, I said, listen, I can't come into your courtroom because I can't give you my name. I can't swear because I'm a Hebrew priest. And he said, that's fine, and let me go.
Uh-huh. Well, it didn't sound like he let you go. You paid the fine, right?
No, but I made that, I told him that, what I said to him is I said, I understand that, you've got a debit against the, against this, whatever, I can't remember the word I used, and I said, I'll go out and offset the books by putting $106 in there so it'll zero out the account. Now, I didn't know anything about special deposit or anything like that, or else I would have probably done something different, but I was just a dummy.
How about looking up the word charge in Black's Law 8?
Charge?
Charge, yes, charge.
I've got it right here. Charge. Okay, here it is. Charge. Charter, chargeable, charge. C-H-A-R. Okay, there's charge. To impose a burden, duty, obligation, or lien, to create a claim against property, to assess, to demand, to accuse, to instruct a jury on matters of law.
Okay, now go down about more and look at charge and discharge.
Okay, charge and discharge. under former equity practice in taking into account before a master a written statement of items for which plaintiff asks credit and a counterstatement exhibiting claims or demands defendant held against plaintiff.
Yeah, mine reads a little bit different. It says equitable practice, court-ordered account, filings by a plaintiff and a defendant. The plaintiff's account, the charge, and the defendant's response, discharge, were filed with a master in chancery. But under equity practice.
So
the charge, discharge.
So that would be liability and asset, charge and discharge?
Yeah, that's kind of like under debtor-creditor, but then the definition of the merger again, which was when two parties have made a simple contract for any purpose, and afterwards have entered into an identical engagement by deed. The simple contract is merged in the deed and becomes extinct. And this extinction of the lesser and the higher security, or like the extinction of the lesser and the greater interest, is called merger.
But in this case, the judge didn't do anything. I just made I just said what I was going to do, like an order. And then I just walked out, and I went and paid the $106. Like I know I got stung on paying the $106, but I didn't think it through. I just went in and prayerfully, walked into the situation kind of more spiritually than preparedly, and acted like that and came out. Now, I don't know if anybody out there's been in an in-chamber hearing, have they?
I know some people have, yes.
I have, also. And the other day I went into a foreclosure case, and there's a friend of mine that a lot of people are copying his land patent stuff. And he was going in to present this land patent to the judge, and I don't think he really even knew he was going in an in-camera hearing, but I was with him, and we went into the regular courtroom in the Superior Court, and then he had previously gotten special appearance. It was more like called a special appearance, but it was exactly like what you were reading tonight about in camera. It was precisely. They went and opened up a courtroom on a different floor, one of the highest floor in the court, and then the only people allowed there were the judge and his clerk and this guy and myself, and the plaintiff attorney was in there for the foreclosure, but he didn't speak. And after about an hour of my friend explaining, when they first started off, they set the rules of engagement, what he could talk under common law as a real man, and the judge said, well, I'll allow you to come in as a real man, but only on the following matter. So we're only going to discuss the other following matter, and we'll allow you to come be in here as a real man. So they talked and talked and talked about this land patent, how it affected the foreclosure case, and then after about almost an hour, the only thing he did was he looked to the attorney, and he asked the attorney, he said, do you understand anything we're talking about? And the guy said, no. He said, I don't understand anything you guys are talking about. He says, Your Honor, you know that I can only do things this, such and such a way, and that was the only time he let him talk, but he did get to talk, And so at least I got a little bit of experience, being able to go in there and see how they do it and what it's like, so it takes a little bit of the edge off of you if you ever have to go in there and do it by yourself.
How did he get the hearing? How did he get the hearing? How did he get the hearing?
I'm sorry.
The hearing.
The hearing?
Yes.
What about it?
How did this fellow get this in-camera hearing?
Oh, he filed an ex parte motion, and he went into the regular court, and he refused to talk to the regular judge, because he wouldn't give up his rights to talk to the judge, so they set up a special courtroom for him just to go in by himself. That's how I got it. So we had to go into one courtroom, then we went into another courtroom. So the regular courts are like on the first floor, and then there's a second floor for, I guess, these special courtrooms. So we went into a special courtroom. And then there's nobody in there except for us and the judge and his secretary, or the clerk, and the plaintiff, the so-called lender or servicing agent, plaintiff, attorney, or whatever. And that was it.
So the judge, did he actually say the words in engagement? These are the rules of engagement, or?
He said not precisely those words, but he said that well, because this guy also had a second case in there, and this one was ex parte motion for a what do they call that thing? The detainer.
Writ of detainer.
Huh?
Writ of.
Whatever, the unlawful detainer, that thing.
Yeah.
And but he also had a case with another judge, his buddy, in the next courtroom over that was scheduled for 2 days later. And at the end of the case, he said he asked him, the very end, he says, I really want to give you this. He says, can you give me a case number? This is after about 15 minutes. And the guy was not prepared enough to have that case number to pull out of his hat to give to him. He said, if you would have brought this matter before the judge that you're going to see on Wednesday in the courtroom 31, and we were in 33, he said he probably would have let you off the hook here. But he said, because I don't have that jurisdiction, I'm going to have to stick to my guns on the original, I guess his original word that he gave, where he gave the house to the plaintiff attorney that was in there.
Mm-hmm.
So, anyways, I just wanted, I don't know, because I just, those are kind of accidental things that happened to me. And I just thought that now I could see a lot more clearly, especially that little traffic ticket thing. The next time I go in there, I'm planning to go back in on another matter just to try it out. And as an example, when you go into those traffic cases, they always want you to, supposedly you're supposed to tell you your rights. Isn't that correct?
I'm not sure if they have to tell you your rights. I think you're supposed to know your rights when you go in there.
Yeah, you're supposed to know your rights, right. So if you ask them to explain your rights to you, they never do it. Because I always start off with them, and they'll say, are you such and such? And I'll say, well, could you explain my rights to me? And they say, nope, we won't do that.
Yeah,
and,
they can't do that on the bench. They can describe you administrative procedures, but they can't tell you about.
Well, then they give you a piece of paper that's got your rights on it.
Yeah, is that all? Just one piece of paper?
Yeah, they give you a piece of paper. They give you a piece of paper. In California traffic courts in Southern California, they give you a little piece of paper every time, because I ask them every time. And, the last couple of times I said, I don't know how I could be in here because I have no idea about any of my rights. And so I didn't plead or anything. Never would I plead. But I would exit the courtroom, and then you go out to the, desk. And then out of the desk...
It's like we need to stop playing games with these people because we know what they want. They want our signature on a piece of paper with an unrestricted qualifier so they can get into the debtor-creditor realm and access our account.
Yeah, so when you go out of the room, they have that piece of paper for you to sign at the desk, and then they got whatever he came up with, and and he goes so fast you don't even really know what he said. But when you go out to the desk, then they've got all this stuff written up that you want you to sign your name to it. So whenever I go out,
on the pony show, and what they say in court's pretty much moot. What's you need to pay attention to is what actually what you see them doing.
okay. But I mean, I've never signed the paper when I go out of the courtroom.
Well, maybe there might be times I want to sign their paper.
Yeah. I mean, now that I'm getting a little bit more educated by all the stuff you're talking about, I could see that could be the case.
How about if I sign this, I say I can give you my name in confidence for future return with my interest. Didn't I just establish a trust? If I want my name back, you're going to have to keep it segregated. And if I tell you it's going to be in confidence, that's the same thing as meaning in trust.
Okay.
Return, so I want it back sometime in the future, but return, I didn't tell you who to return it to.
So can you
Maybe
say
I
that?
want you to return it to me, maybe I want you to return it to the beneficiary, or maybe that could be somebody different. I don't know. It depends on what my intent was.
So,
And then what's my interest? And what is my interest? Well, everything that's generated off of that signature is mine. That's my interest.
Christian, can I add something there?
Yeah, go ahead.
For Jacob. I think that's an interesting thing that you did, Jacob. But yeah, too bad you didn't hold off from paying so you could see what the real result was, because it kind of nullified the whole experiment. But I think you said right off the bat, I understand. And if you say that, that would be a game over right there in terms of you giving them jurisdiction. And I think you're not differentiating between understand as a contract and can you tell me what my rights are. It's not saying you don't understand doesn't mean they're obligated to explain anything. It's just you're saying actually you're not going into any kind of a contract or you're not standing under their jurisdiction.
Well, when I ask them what my rights are, I want to put them on the hook. If they're not going to tell me what the rules of our conversation are going to be, then, what do I have anything to do with him?
Well, I'm with Christian. I think you're obligated when you're stepping into their house to have read their rules and know what the rules of their city or house is, so to speak.
Yeah, but I didn't step into their jurisdiction. I didn't go through that little bar thing.
Well, you said I understand though, so.
It's much more than that. It's
Many things.
Trust, if you're in any way connected with a birth certificate, Social Security, driver's license at any time, once in the past year, you're obligated into the public trust.
Okay.
And then even if you're not, they're still going to assume that you are.
Yeah.
And it's still up to you to prove that you're not.
Well,
Actually, it's not an assumption, it's a presumption, right, Chris?
Right.
Christian?
Yeah. Mm-hmm.
Well, Christian, when you when you sign the ticket, you sign the ticket for whatever stop sign or speeding, whatever the deal is, and when you're signing your name, and it's your regular,
Well, let's start right back there. The guy asking you for your driver's license, your registration, and your insurance.
Yeah.
He was asking you to volunteer to give your property to him.
Mm-hmm.
No compensation.
Okay.
So then you gave it to him voluntarily, and then you signed without a qualifier restriction, and they're formed this debtor-creditor colorable contract.
Well, I mean, I signed all rights reserved. I never signed.
Well, all rights reserved for what?
Because that's my name on my driver's license is all rights reserved.
Oh, okay.
Full signature, did you put by? Or designate a trust position?
No, on that case I just put ARR, and then under it I qualify by what it means. It means all rights reserved, in big letters.
Well, was there an address there?
On the ticket, yes.
Okay, was that your current address where you're living?
Well, they always like to do that. You know, I'm more than one citizen, so I always pull out when I first get stopped, I don't pull out any U.S. ID.
Well, you know, it doesn't really matter to them whether or not
Yeah,
you're
I
living
know.
there.
Excuse me, I
Once they
know.
got your signature on that, they generate the bonds in the background, and that's the big thing from them. That's the big ticket. You know,
So
and then they, you know, issue a warrant for your arrest if you don't show up, and someday maybe they might catch you. But they don't really care. They've already taken and gotten their money.
Oh, okay. Well, yeah, nowadays here, anyways, they have a separate agency now inside the courthouse.
Yeah, but let's go back. But now we got these debtor-creditor bonds attached in the background running with humongous sums of money that you aren't aware of, but yet you're abandoning them and you're not claiming them under trust.
Okay, I want to go in and claim those. Let's say, because one thing right now is, I don't want to bore you guys, but let's say somehow I ended up having to pay $400. So now I want to go in and, I mean, could I take the piece of paper that says the $400 on it, and then use that as trust res, and then go back in and then order them to give me the proceeds from the bonds?
Yes, because the $400 charge doesn't buy the judge's lunch. It's the bonds running in the background that they want your signature that's generating all the funds.
So I would just go back to the court,
getting their cut.
Back when I figured out my rights.
Everyone's getting a cut off of these bonds, except you. You're the one generating funding the whole thing, but yet you're not getting one dime of it because, by definition of the word give, what did we say it was? You're being tricked to voluntarily transfer your property, your signature, to another without compensation.
Okay, so how do you handle that or reverse that or what? So the police comes up to me. Can I have your driver's license, registration, insurance? And then you say, well, are you expecting me to voluntarily give those to you? He'll
play it that way, but you might want to say, I'll give you my name in confidence for future return with my interest, and then sign your stinking paper.
And write that
statement on
and write that statement on there also, right?
Huh?
And write that statement. I'll give you. How'd you say it?
No, I don't need to write that statement on there.
Oh, okay.
I don't have to. In fact, I don't even have to sign with a qualifier. If I really knew my stuff, how could anybody say that it was not my intent to give you my name in confidence for future return with my interest, other than myself? There's nobody in the world that can tell me different except me, myself. So if that was my intent, the only thing that they're going to see is the manifestation of your intent. And what's that?
It's going to be your deed or your act, your behavior.
Yeah, your warranty deed, your trust receipt, your UCC-1 filings, your county recorder notices and that. That's going to be the record titles or the manifestation of your trust intent. So everything that they're doing, you got to counter. You got to come in with this contract, this code of contract that they've got under debtor-creditor. You got to create a counter to that. You got to create a counter record to that. You got to mirror image everything that they're doing to you. You got to mirror it back the other way under trust. And you got to start creating the records of all these trust things in opposition.
Christian, if I have a $400, paperwork thing, then claim that and transfer it to him?
Yes, I would.
I mean, the same 1+3 way?
I mean, the moment I handed it back to the officer, the ticket that I signed, I transferred trust res, and that moment he took it into his hands, that...
Oh, you state I'm transferring trust res?
You could. Remember, no party in the trust needs to know or understand that a trust is being formed. And is there any wording in here that has any kind of implication of the trust? I give you my name and confidence for future return with my interest.
But is the policeman, is he the trustee for the city?
He could be a co-trustee.
Okay, so if you tell him that this is trust res, you're giving him an order to pay the ticket with it.
Well, I'm just forming the trust right there when I hand it to him, so why don't I just give it a little time to soak in first and prepare the documents for records to prove the trust after I claim it.
Okay.
Start executing the trust.
So when you transfer the property, you transfer it to the court? That's on the ticket?
No. You know, I transferred it to him. He's an agent operating for the court.
Oh, you transfer it to the agent?
Yeah. Isn't a cop an agent in the court?
I don't know, Christian. He
transferred it to the cop. I don't know what the cop did with it. He gave it back to the court.
I mean, he goes and he turns the thing in, right?
Yeah.
And he writes up a note. See, if you told him to, this was trust res, and I order you to, when you get back and place your ticket in the whatever it is to the court,
The point is that the moment I'm having a confrontation with anybody or whatever, or even not a confrontation, the question is what type of relationship am I forming at that moment, especially at the time of signing. Was it a trust estate, an equitable trust estate that I was forming, or was it a estate under debtor or creditor? How am I holding property? What estate am I holding my property in?
Jacob.
Mm-hmm.
I wouldn't get in that confrontation with a cop. I would just go ahead and sign it. Don't say anything to him. Put your three little dots in front of it and go from there. And then before you go into court, then you turn around and you move the titles. You do UCC, and then you move it and move the titles to UCC 3, naming the court or the cop the trustee. And then ordering them to settle the matter and give you back the interest that was created by it, by your signature.
So on the 3, you put the policeman's name?
Or the court.
Or just put both, right?
Yeah. They're both trustees.
Yeah. So just
if you appoint them, they're both trustees.
Mm-hmm.
Yeah, the point is you're the grantor. You can make trustee anybody you want.
Okay.
But so you don't get shot out there on the highway.
I know, I got it.
Because these cops, they think everyone's a terrorist. Just go ahead and sign it. Put your little dots. Smile at them. Have a nice day. And then
plus everybody's going to copy you too. So other people, you don't want them to get into some confrontation. So it's going to be easier for them to do it.
Get in the confrontation with anybody.
Yeah, keep it peaceful. Peaceful.
Yeah.
Yeah, I agree.
Christian?
Yeah, who's this?
Yeah, this is Dan from California.
Yeah, Dan, go ahead.
If I could, I know you guys got off into courts, but if I can get back to definitions where we started, I was in Black's Law, and I found a real nice definition of a word that illustrates the duality of public and private, and they actually define the word Blackacre, which shows up in Gilbert's Law all the time. And it basically defines the land of Oz, a fictitious tract of land used in legal discourse, especially law school hypotheticals, to discuss real property issues.
What's the word? What's the word? What's the word?
Blackacre.
The Blackacre. Oh.
Yeah, that's great. And then it's additionally defined as Blackacre, the most celebrated tract of land in the world of the law. Blackacre is wholly mythical, yet totally real. It's a concept living in the realm of the mind and doubly valuable since much of the law of property has the same type of reality. That was defined by John E. Cribbett, Principles of the Law of Property. So there you go. We're living in Oz.
1975, second edition.
And its counterpart is Whiteacre. So when you have a duality like that, it makes sense to merge the two so that you can realize the matter.
Yeah, Blackacre is the debt title and Whiteacre is the asset title.
Exactly. So, as above, so below. There you go. I thought that was an interesting definition I came across yesterday. I was cracking up.
Well, thank you for that. Huh?
Christian,
Yeah,
I had an interesting conversation with Swift Arrow the other day. In my endeavors to get him to become a postal zone, it became quite clear to me that a postal zone issued by the UPU out of Europe allows you as a postmaster to set the laws within that jurisdiction. And Swift Arrow was so thrilled because he had been soul-searching how to protect the driver's license and the registrations that are being issued through United Nations of Turtle Island. And I spent a couple hours telling him how powerful it is to have a postal zone, and it would certainly be in our best interest is to pursue a little more research about, he was putting most of everything in the United Nations of Turtle Island under the postal zone of the United States of America. Once you realize that by creating his own postal zone, he separates himself through commerce out from underneath the United States of America and can conduct commerce separate from the United States of America, of which they have to have an easement in order to interface with him. And here's an opportunity for everybody to stop and think for a minute. If you were not part of the postal zone of the United States of America and all the subsidiaries therein, you are claiming yourself under a postal zone that they have no jurisdiction over. Therefore, they have to go under international law, and they have to go under easement with diplomatic and ambassador type of channels in order to interface with that other postal zone. And I just wanted to bring that up since Jacob was talking about traffic citations. Swift Arrow was so excited, he called up the UPU over there in Europe, and within 45 minutes, he had gotten himself a postal zone that included Canada all the way down to Peru for the United Nations of Turtle Island Indian tribal nations. And he was just absolutely just thrilled to death.
How about a termination of employment and a termination proceeding?
I did the termination of agency in the state of California in regards to the driver's license issue, and that actually goes, the termination of agency goes back to the Indian tribal nations of where they didn't feel they were being beneficiaries properly by the United States of America. They had every right in the world to terminate the agency, and that's where I started that paperwork, is based off of the Indian tribal rights.
And also the definition of certificate of correctness.
If I do have some of that information on termination of agency, if individuals part of our group here wants some of that information on terminating an agency, I'd be more than happy to forward that to you. A correctness. What's the definition of?
And straw men, straw parties are considered employees. They are being employed by the United States, and we need to terminate that employment through a termination of employment statement.
And how do you do that, Christian?
Black's Law definition, termination of employment. All United States citizens, a.k.a. straw men or straw parties, are all employees of the United States. They're being employed.
We do that through the
Black's Law definition, termination of employment do a termination of employment statement to them. Terminate that employment.
To who?
Who the employer is, the United States.
D.C.?
Yes. Look up termination.
That would probably be most suffice to send it to the Treasury/IRS, wouldn't you think?
Yeah, along with possibly that look up certificate of correctness.
Oh, wouldn't the WH do that, CW?
Well, that may be a certification that you're a non-resident alien and not connected with the United States and not a United States citizen. Yeah, that's possibly.
Because you
Well,
can add...
doesn't also filing yourself as an international citizen, doesn't that kind of put the presumption away that you are not claiming yourself as a 14th Amendment citizen?
Possibly, it might be enough, but I'm just saying I ran across this definition and looked at how we can use this termination of employment. You know, just send them a termination statement.
Or because of the
I quit.
Because of the WH, we can write our own WH forms. Can't we insert that in there that we terminate employment with the United States and then send that to the IRS, chief of the IRS, the commissioner of the IRS?
Right. And then this termination proceeding, that would be a dib hearing.
Well, there's something else, because I've already been through this once. You have to file an error presumption. Instead of claiming yourself as a employee, you have to clarify that they have been in error and that they've been presuming that you're an employee. So you have to word it in such a way that you don't admit that you were an employee, that there was a mistake in presumption. Therefore, you issue an error presumption, and therefore, with any residue considerations they may have, then you terminate whatever is left.
Okay. All right.
And that could be done on the WH and then get a dib hearing.
Mm-hmm. Yeah, I kind of tend to agree with that.
Certificate of correctness. Number one, it says a document that corrects an error in an official document, such as a certificate of incorporation.
There you go, right there.
Well, the all capital guy is a trust, right, Christian?
Right. Yeah.
Okay, so if you change that relationship, I mean, isn't there another trust in that you're the real man?
No, not the real man. I don't think so. I mean,
couldn't we just make a trust with the real man?
No, because you got two different trusts. You've got the public, and then we got to go into private. We're creating a new trust after we terminate the other trust.
I'd only have two.
I guess you can have as many trusts as you want, you know.
Yeah, why don't we just have two? That way you can play both sides all day long.
Well, that's basically what we're going to do.
Well, don't we want two trusts to do that?
We have a trust on the private side, a trust on the public side, and probably an LLC to access the trust on the public side.
Why can't the flesh and blood man be the real trust?
Because you've already been given a trust, Jacob, through God.
Can't commingle sides. Can't cross one side over the other. They must not cross sides. If they cross sides, you just breach trust, you commingle. Each side's got to stay separate. It's got to stay in special deposit. If you cross sides with either side of that, you commingle, you breach trust.
So you have to erase the one side in the public? That's the point?
Yeah, that's what we've kind of, CW's come to determine, is that we get rid of the public side and then create the private trust and then have the LLC to run our business on the public side.
Well, since we already have one on the public side, there's no way to use it?
No, look, if there's anything possible way to them to associate with that old straw man trust name,
okay,
I want to terminate it. That way,
okay.
There's no possible way that anybody can associate anything with that because it does not exist.
So what happens to that cap man under international treaties?
He's gone.
It doesn't exist.
That also comes out, Christian, right? Or if you're if you're a multiple citizen, you'd have to also pull that out at the root with the UN and all that?
Well, the IMF is one central agency that runs the whole world, where the individual master file, that's the one I'm talking about. And once that terminates, anything that's attached to that, your numbers or whatever, once that trust is terminated, it's gone. And that's what the whole objective is. That way we don't commingle the two trusts together or go into breach of trust.
Michael?
Yes, sir.
Are you sure there's not a higher one called the business master file?
And where do you get this information?
I've got some guys that are doing it. They've actually figured out that it's a business master file that's over the individual master file. I've got all the stuff. I'll send it to you tomorrow, Michael.
Please do. I'll take a look at it and forward it to the group and let them take a look at it.
They've really figured something out, these guys.
Okay, well, we need all the information we can get.
Yeah, so that's why I'm throwing it out.
Okay, where were we? Back on topic here.
Definitions. Oh, you were back at telling us that we want to get the bonds from the traffic thing, and obviously, there's another thing that goes along with that. If you had a traffic ticket, or if you had a mortgage,
well, Jacob, let's let somebody else talk for a little bit.
Okay.
Anybody else want to pick up on that?
Well, I don't want to necessarily pick up on that, Christian. This is Floyd.
Something else then?
Yeah, it's in line with what we're talking about. Essentially, I'm working on my my telephone bill, and I came up with my indenture today, and I wanted to ask a couple questions on what I'm doing here and make sure I'm on track. And what I did in I put private trust indenture of the Sprint Trust, and I gave my address, and then I put, started out with my witness, let it be known that Floyd Bradley Howe, hereinafter known as settler, grantor, beneficiary, this blank day of April, in the year of 2010 of our Lord, being of lawful age and a sentient being on the land of the Commonwealth of Virginia, exercises his right to name as trustee to the private trust of the Sprint Trust, the person known as the Sprint Nextel Corporation, and its president, CEO, and director, Daniel Hess, along with CFO Robert Bruss as co-trustee, in addition to Chairman James Hance, also as co-trustee. Now, I named all of them as trustee because I didn't know exactly who would get this, although I'm going to direct it to the CFO. And then I put in there my purpose. The purpose is, it is the purpose of the trust to hold the interest of the beneficiary until further notice for future return with his interest. Does that sound okay?
Yeah, I might want to keep it kind of even more simpler so I could shoot from the hip.
Okay, well, how would you say, how would you simplify that? It is the purpose of the trust to hold the interest of the beneficiary?
Well, it's just like that statement. I give you my, whatever it is, property in confidence for future return with my interest.
Okay, so it is the purpose of the trust to hold the confidence of the beneficiary until further notice for future return with his interest?
Right. Now, I didn't say who I would want to return to. In fact, maybe I might change my mind and say I don't want to return it at all. I want you to do a conversion and apply it towards the debt. Prepay the thing for, say, 2 years.
Well, what I
Yet under my intent, under the intent, I put it is the intent of the grantor to relinquish to the beneficiary the equal amount of the benefits provided by the Congressional Act of HDR 192 of June of 1933, charged by Sprint Corporation in the services provided in the public. Since of that date, all services and goods are prepaid.
Mm-hmm.
Well, that kind of tells what I might be aiming for.
Is there any reference to or alluding to a special deposit?
Yeah, on the bill itself, I put private non-negotiable special deposit.
Okay, all right.
And then on the back, I put without recourse paid to blank grantor Floyd Bradley Howe for Floyd Howe, straw man. And then I put, pardon?
Read me the indenture again.
Okay. Okay, I started out, let it be known that Floyd Bradley Howe, hereinafter known as settler, grantor, beneficiary, this blank day of April in the year of 2010, so on, being of lawful age.
Well, I really don't need to put, say, settlers, and what was the other one? Settler,
grantor, beneficiary.
Too many redundant and repetitive terms there. One's good enough.
Okay, I'll just put in grantor beneficiary then.
Yeah, at this particular time, if I'm granting, I would put myself as grantor. If I was coming in and going to reform something, I would call myself settler. They're both synonymous terms. But if you look up the Black's Law definition, the term settler is one who has an interest in the account.
Mm-hmm.
So that gives an implied that, hey, this account's already been set up, this trust's already been set up, and I'm going to come in to maybe straighten it up. But if I was forming the trust and had been formed before, I'd be coming in as grantor, because I'm going to grant something. So I would put grantor / beneficiary.
Okay.
And keep terms out.
Okay.
Now, if we form the trust and we already have some other communications, I'm going to communicate now being settler / beneficiary. If I'm not talking about beneficiary stuff, then I'm not even going to put that term even in there. I'm just going to come in as settler.
Mm-hmm. Well, in this case, what I'm doing is I'm sending an instruction with my special deposit that'll be attached to my the bill.
You know, it could be. I wouldn't even put beneficiary on there because no party in the trust needs to know trust is being formed, and nobody needs to know who the beneficiary is, as long as the beneficiary can be identified some specific way sometime in the future in the life of the trust.
Yeah. Well, the indenture is going to stay in the private anyway, isn't it?
Yeah, but I don't like pulling my pants down and showing everybody what I got.
Well, I wouldn't pull it down. I wouldn't pull my pants down until I was in. Should I have to go to court and go in?
I don't have to. Do I? Do I have to tell them who the beneficiary is?
No.
No.
But I thought that I was setting this up as a record.
Okay, if I was going to specifically name the beneficiary, then I might specifically name him.
No, I'm just saying that my understanding is that this stays private, and I'm just using this as a record so that when I go into, should I have to go into Cameron, that I have this already drawn up.
Right. Well, I'm just saying that what I would do, I would keep it a little more private. I would not disclose as much maybe as you would. Go ahead. Keep on reading. Pick up where you left off.
Okay. Then I then I went ahead and I named the Sprint Corporation and its president, CEO, and director, Daniel Hess, along with the CFO, Robert Bruss, as co-trustee, in addition to Chairman James Hance, also as co-trustee. That all comes under my introduction of witness. Okay. And then in the purpose, I put it as the purpose of the trust to hold the interest of the, to hold in confidence the interest of the beneficiary until further notice for future return with his interest.
Okay, the first interest, you're talking about your interest, that's not interest. Let's say that's a principal. That would be the red.
Okay, so I could just say to hold the confidence of the beneficiary.
What was trust res? That would be the bill that you signed your name to.
Yeah.
That you're going to use as special deposit.
Well, I could call that a special deposit then.
Yeah, you could, because you're pretty much not hiding anything or trying to keep it secret that you're forming a trust.
Well, I'm calling it
a principal or trust res.
Okay.
I'm calling it interest.
Well, I could say principal, and to hold the principal of the beneficiary until further notice for future return with his interest.
Yeah, because when I give you my name in confidence for future return with my interest, that's kind of like alluding to, you may think that the principal is the interest, but it's not. Because once this interest term portals in on your side and debtor-creditor, it's going to be two things. It's not going to be the principal. It's going to be the interest on the principal over in their realm. But on the equity side, it's going to be, really the same thing.
Okay.
Do like they do. They get you in this debtor-creditor stuff, because that's what they're good at. We need to learn how to do wordsmithing also.
Well, then I could just say it is the purpose. Let's see. It is the purpose to hold the principal of the beneficiary. I don't even have to mention trust then.
Right.
Just put it as the purpose to hold the principal of the beneficiary until further notice for future return with his interest.
Well, you could put in confidence or in trust.
Okay. Principle of the, let's see. It is the purpose to hold the principle of the confidence.
In confidence.
Or to hold in confidence.
Or hold the principal in confidence, or in confidence hold the principal.
Okay. Yeah, to hold the principal in confidence. Okay, do that. To hold the principal in confidence until further notice for future return with his interest.
Mm-hmm.
Okay. Now,
just a quick question: Is the principal? So the property is the principal? Is that what you're calling the property then? The principal?
well, the principal is the res, the trust res. Yeah.
Okay. Thanks.
And then I read you the intent. Okay. Now, in the instructions, what I did is this. I put instructions with special deposit. These are instructions along with the special deposit of April blank 2010 to the remittance form of amount due by May 2nd. That's what this bill says. Amount due by May 2nd. So that's what I called it. Remittance form of amount due by May 2nd. So then I put under there, hold my interest until further notice for future return with my interest.
Again, I correct that.
Yeah, I put hold my res, or hold my principal until further notice for return with my interest.
Right. Yeah.
Christian, should Floyd mention something in his indenture to the effect that he's relying on the trustees to exercise care, skill, and caution or prudence?
Yeah, he could.
Where would I put that? In my instructions?
Yes. Uh-huh.
Okay, hold my principal until further notice for future return with my interest with care and something like that.
You do some trust research, find out that, in care, all the words that he mentioned there is connotating that there has to be something specially done with this that sets it up as being as being private. It can't be commingled. It has to be treated special because that's what this is.
All that's explained in the beginning of Chapter 6 of Gilbert.
Okay. So then I'll put something like that. Hold my principal until further notice for future return with my interest with care. Let's see.
What I've been doing is I've been keeping it simple until everybody can grasp the simple stuff before we start throwing in more technical terms and we start getting into a more fuller, more complete indenture. If we throw a bunch of words at everybody with all this complexities and stuff in there, it's like we don't have the basics down yet.
Yeah. Well, what about the word surety? Is that a place for that in here?
Well, actually, surety is what? It's really a pledge. And what is a pledge? It's really a promise. What's a promise? A bond. It's my word.
Yeah.
In other words, it's a trust again. A surety is a trust.
Yeah.
Pretty soon you'll start seeing that all these words make a circuitous roundy round, and you come back to the same point where you began. And now you traverse through the onion skin layers down and into the center, and you come right back where you started from. You're back in Kansas again. Really, all these words mean the same thing, practically. It's just maybe called something else during a different time frame, different tenure.
Mm-hmm.
So you're almost saying, Christian, it's almost like how you use them that proves your understanding or not.
Yeah, it's like what I read earlier. Words are switches that complete the circuit as the current would flow. Words make up the verbiage for a trust indenture. And our words determine the venue or the jurisdiction that we're going to operate in. And our words determine the type of estate we hold our property in. And if we use debtor-creditor wording, our estates will be held in the jurisdiction of debtor-creditor. But if we use the words trust and use a vocabulary trust along with knowing and understanding the debtor-creditor words, we can control the jurisdiction of our estates simultaneously. And the private, non-negotiable, no trespassing, special this, special that, example, special deposit, close, and similar words are private trust words, which means we manifest the private by saying and doing something as a protective order or give or grant the privateness of the matter. It's privileged, it's private, it's confidential, held in reliance, in confidence. It's a trust, and it's only enforceable under trust and not debtor-creditor.
But at the same time, Christian, do we not also need to maintain a public colorable facade as well, and not give away all the answers to the test?
That's just what I said. That's what I meant.
Right.
Okay.
We have to be in control simultaneously with both sides. We have to be able to speak simultaneously that foreign language, colorable language, but at the same time know and understand that this is trust,
and doing the trust on this side, which is the mirror image of the oath.
Excuse me. What I was going to say is, after giving them instructions for the special deposit, then what I did is I do an instructions for a special deposit follow-up, and in that, that's where I can, I'm going to apply the total special deposit of April blank 2010 to the amount enclosed on the amount due by May 2nd form dated April blank 2010, and instead of putting by beneficiary, I could just sign that by Floyd Bradley Howe.
If that's the indenture formation of trust, I'd sign that by grantor.
Well, actually, this is a follow-up to what the grantor has already set up, and so now the grantor, you said, is out of the way. So now as beneficiary, I have to give the instructions as beneficiary now, don't I? Because the grantor is now out of the way.
Is beneficiary in a position to give instruction?
I might have given them all at once as grantor of the instructions along with it then, at the first.
Well, I can't.
Once a trust is formed, I don't think you can come back in and say, who signed it. You're going to sign. You didn't put any qualifier. Who signed that?
Well, I did on the instructions. I put grantor.
Okay, but on the second instructions, the second time you're going to send something, you didn't sign any particular way.
Well, on the follow-up, what I'm doing is I'm giving instructions to the instructions that I had already given them, because I told them to hold the.
You make reference to the first one that said that the instructions are to follow?
No, I said this.
You might want to true that the first time that you sent them that was the instruction. So I would put in there that our instructions are to follow at a later date. You could also put in there a little caveat in there, as can be amended from time to time. That's what they do to you in these bank accounts.
Yeah. Okay, so then on my instructions,
that's self-open. A little clause in there like that, to be amended from time to time.
Okay, so then that's where I would put that on my instructions. To be amended. Yeah. Because that has to be out in the public.
No, it doesn't. The instructions don't have to be in the public.
Well, I'm giving the instructions on the public side, and holding the indenture on the private side. In other words, I'm holding my proof that there is a trust in private.
Right.
And I'm giving instructions on the colorable side to let them know that this is what they're to do. And that's where I could hide.
I would keep all that stuff private, really. The only thing that you need to make public is that, say, if I'm going to open up a bank account and I'm going to open it up in trusts, the only thing that the bank has to see, they don't have to see anything of the indenture other than my authority as a trustee.
Right.
Bring in the certificate of authority stating that I was trustee, and that's the only thing they're required to see to set up a trust account. I don't have to send them the indenture, the instructions, or anything on that trust. They got no business to see it.
Right, exactly. All I'm saying is that in the instructions that I'm giving them, I'm telling them how to really settle this account. Is basically what I'm doing. And if they don't settle the account, then they're in breach of trust, and that's when I bring out the fact that I have created a trust in private. In other words, in the judge's chambers. Now I show that this is what I did. I created created a trust.
Right. Did
And
you
he
give them a
felt-
timeline? A certain amount of time to do it in?
Well, when would I put that in my indenture?
Yeah, because if you got an open-end contract, when does it come when it's supposed to be due, that you're supposed to do something? If I can give them, say, 30 days, then if I don't put an ending date on it, when does it end?
Okay, then that's what I would do in my instructions. Apply the total special deposit of April blank and close on the amount due by May 2nd form dated April 2010 in the next 10 days.
Yeah, give them a time limit, what is reasonable.
Yeah, well, 10 days is reasonable. I could put in the next 10 days to close this account.
Yeah, and then set a specific date by such and such a date.
Yeah.
There's no question that it can be construed as, well, when it started, when it ends. Because how
Okay.
could you certify a default or a breach of trust when you gave no closing date?
Okay.
Christian, shouldn't he also put in there that their failure to execute and close out that account would be their demise, that they will be in breach of trust?
Yeah, you could do that.
Yeah.
Here's a little bank deposit slip thing that says important information for a bank deposit account. It says when you opened your account, you received a deposit agreement and a fee schedule and agreed to your account would be governed by the terms of these documents as we may amend them from time to time. Now, why can't you use something like that to use that in your benefit? So,
Yeah.
it says you agreed to your account would be governed by the terms of these documents as we may amend them from time to time.
Yeah. Yeah, I'll put that in my instructions, and then on my special deposit follow-up instructions, or follow-up to the instructions, that's when I'll put a closing date.
Yeah, remember you're talking to a dummy, and you got like a domino. All the dominoes got to be in place, because when you push the first one down, if there's one out of place, they don't go down.
Right. Okay, yeah, well, that shouldn't be too hard to do. Now, when I do my UCC 1, and I go to put that in. Let's see, I'm going to give, when I mail this out, I'll have my number. Now, is it necessary to? I was talking to Bill the other day, and he said that it's better to do registered mail than it is certified mail, because the registered mail is in international.
If you're making a payment of any kind or any kind of private documentation with any kind of substance to it, send it registered mail.
Okay, now I can't really make my UCC 1 out until I mail this in, because I don't have a registered mail number until I go to mail this.
Well, yeah, you do, but you're just not thinking of it. I'm going to take a registered mail number, and I'm going to stick it on an envelope and put something in the envelope, seal it shut, and I'm going to mail it to me. Now I've got a canceled RA number that I'm going to use for this whole setup.
Okay, I already have a canceled RA number. I could use that.
Yes, right. You then use that on the UCC.
So I can use that registered number on anything that I do in any of my UCCs or transactions, whatever I'm doing privately.
Yeah, now to do one better, I would make up a unique numbering system using just that one number, that RA number, by putting some additional numbers on the back so that it would make it like include my initials, and then after my initials, say the RA number, and then another dash, and then I would put 000 through 999. So there, I just claimed 1,000 unique numbers.
Okay, that would be just for my file, though. That wouldn't actually go on the envelope, would it?
No, I wouldn't have to put that on the envelope, no. And then I could send a new registered mail number to send it, and I don't have to worry about that number. That number just went with the mailing.
Oh, okay. I see. Okay. So I have one registered number just for my own files, and then each other registered number I just discard those.
Yeah, so I only have one RA number followed by my initials plus a sequence of numbers that I claimed on a UCC1. And then I'm now going to use those numbers in a sequence. So my first number would be the RA number, my initials, and 0000. That would be the first one.
Yeah.
Do this whole sequence. And now that unique number with 0001 now would be my next one, whatever I do. So now they're all separate now.
Okay.
And I only do one claiming of one RA number, and I don't need to go and get a new unique number each time as a master control.
Okay. Well, that makes sense. That's a good idea.
I don't have to worry about when I mailed it and I don't have an RA number because I always got an RA number.
Right, yeah. Well, that's what I was trying to figure out. How do you know when to get an RA number? Okay. Okay. Well,
Quick question, Christian. I've been trying to figure that out. You can send private documents by registered letter. It doesn't turn it back into public or anything.
By registered mail, yeah, it's international, so.
Does it still keep it? It doesn't ruin a public. I mean, it doesn't ruin a private information, like by making it become public, because you know how you get that issue with trying to enter evidence. And
you can actually send it by regular mail as long as you just send it with a 3-cent stamp.
Yeah.
If you use anything other than a 3-cent stamp, you put it back into their realm.
So it might not be a good idea then to go registered then necessarily.
Well, no, registered mail is international, so it is different. You know, that in that particular case, you know. But I could also send it by just, with a 3-cent stamp, which is not under the USPS.
Yeah, I've seen it done. I got letters in the mail. We tested that.
Well, who would mail it then with a 3-cent stamp on it?
My friend did.
Only those that know how to use it.
Yeah,
he did right.
I don't think who else would mail it.
I'll send you, I photocopied it, and I think he just put, what did he put? Something like without prejudice, something else, I forget. I wasn't paying too much attention to it, but I can send you a copy with the writing in text, because it's kind of hard to read. I was going to ask you something else, Floyd. You were making mention about the prepaid thing.
Yeah.
I'm thinking, I wonder if it's probably, does it make more sense to not say too much on how, just to say what you want done, because everyone's going to look after it. Whereas if you say, well, because this, I haven't heard you come up to it, or if you already passed it, you said something about because this is prepaid, and maybe you don't want to be making statements like that, because, you know, then you might be...
That's only made in my indenture. But the only time that I'm going to use that indenture is if I have to go into Cameron.
But do we really know how the system really works? And do we really want to be put on the spot like, well, why do you say it's prepaid? How do you figure that? How are you going to, you know what I mean? Maybe it's just best to leave that out.
HGR 192 says it's prepaid.
Okay. Well, you got an explanation there.
You're going to claim that. You're going to have to prove that.
That's my point, yeah. Getting back to Christians, keep it simple, stupid. Less you say, the less you have to stand, prove.
Yeah, the old maxim says that anything I claim, I got to prove. He who claims trust got to prove trust, but anybody who makes a claim on anything has to prove it.
You just want to tell them what you want done, and that's it. Just do it. Settle it.
Unless you want to do this and say that I am prepaying this account for the next 2 years.
Well, that's what I am. I am prepaying that account for 2 years.
Okay, with this special deposit.
Yes. No, I didn't put that in my I didn't put that in my instructions. Although I could do that.
Just say prepay this account for the next 2 years, which is, of course, a whole different...
It's kind of like, I don't need to know what color underwear you got. All I just need to know is, do you have some?
Yeah, and if you're just using prepay in that sense, I was making reference to that.
Okay, let's see here. Trust.
The point is, it's not to include any more private information that we need to, in order for them to accomplish what they need to do. They don't need to know.
Yeah. Okay. That's the wrong one again. I keep trying to come up with my instructions, and I keep getting my special deposit follow-up.
Why is it you want to put separate instructions? Why don't you just include it all at once?
Well, I thought that, let's see, in order to...
But pare it right down, keep it real simple, and put in that amended from time to time. To be amended from time to time, then you can take a couple of weeks and think about it. And if you want to add something, that's easier.
Well, I want this to be in by May 2nd. Let's see.
Is it safer for him to just put the by ... full column signature for now?
Well, actually, I can just put by. Well, actually, if I put.
I don't think they're hiding anything or wanting. You're coming right out and telling this is a trust. I don't think there's any reason why you shouldn't sign except by sublet or by grant holding.
Okay, great out.
Because on the bill that I'm returning to them, I put grantor. I signed my name, grantor, like Bradley Howe.
Right.
So they know that I'm creating a trust. Even though I haven't told them I'm creating a trust, I mean, basically they know I am. I will.
Mm-hmm.
Christian?
Yeah, go ahead.
Can I ask another a question off of Floyd's topic here? How does a bankruptcy affect the ability to claim, prove, and enforce the trust?
Chapter 11 and 7, those are all statutory trust. I don't think it really is going to make a difference how to claim it or prove it.
had a bankruptcy hearing. I had to file Chapter 7 just to save my house, to buy me some time, really, because I didn't have many options at that point. And they're trying to lift the stay, and I don't think I'm ready to claim trust. I don't have standing. So it's a tough one. I mean, I'm not really concerned about the property. I mean, I don't really care whether they take it or not. I'm not that attached to it. But just wondering how the bankruptcy, in a bankruptcy court, it can be converted into an equitable court, I'd imagine, just like any other court. And also, if I'm in that court with the trustee and the judge only, and there's no spectators, could I consider that an in-camera hearing?
Yeah, it could be.
That's interesting you said that, CW, because I've been in the court many a times, and this is when I was in the debit creditor, and was going back and forth, and then the judge told me to sit over on the side, and then he emptied the entire court. And then I was the only one sitting in there. And it was interesting that you say that. But he still had his robe on.
Oh, he still had robe on?
Yeah.
Well, sure, he put you in jurisdiction when he told you to do something, and you did it. That's when he grabbed you.
Yeah, that's when I didn't know better.
Yep.
Because they wanted me to sign, and I wouldn't sign anything. They wanted my Social Security number. I wouldn't give them anything.
That's
so
a classic one, though.
Yeah, they put me in jail. They put me in jail for 3 months.
That's a classic one when they say, okay, well, just go over there, sit down we'll get right to you. And as soon as you go, okay, and walk over there, you just go to the jurisdiction right there.
Yep, and my little girl was just born a week before.
What was the charge?
Driving a vehicle with an uncovered load, concrete.
Wow.
That's exactly it. That's crazy.
But I wouldn't budge, and they finally let me out after 3 months.
Well,
That was 10 years ago, so I guess I can go back and bill them.
But to be thrown in jail for 3 months, the uncovered load, I don't think would get you 3 months. They must have got you for contempt or whatever colorable charge they could have put on you for defiance or something.
yeah, there used to be a case, I used to know it, but I forget what it was titled now. There was something like you get to charge like $83,000 an hour.
That's Transference versus Tampa.
Okay. And you could bill them for that, so.
Well, California's broke now, you know.
Well, that's great. You know, it's all horrible money. It all spends just as good as the rest. So all I want is the debt. Create the debt. That's money. That's credit.
Yeah, it's my understanding that the maritime liens, some of the folks out there that are doing the research and cashing those suckers in are saying getting real close to being able to cash those suckers. So just go ahead and do your negative avertment on these guys. Go ahead and get your judgment and set on it until it's, cashable.
And then you can put in a special deposit in the Treasury with the asset.
There you go. That's a thought.
Let the Treasury do the conversion.
Would you ask the Treasury to set up a legacy account or something to deposit the funds into? How would you work that?
You might want to disperse it back out, maybe through that.
And then what? Open up like an LLC or something like that to dump the funds into.
Yeah. Mm-hmm.
Or maybe even loan it back to the government. Say, hey, look, once I have control of this, how about you invest it for me, and I'll just live off the proceeds.
Well, that's what they're really going to do. They're going to invest it for you, and they're going to give you the proceeds. So nobody really knows how. Just short time that they're going to invest it. How much are they going to be making off it?
Depends how many times they fractalize it.
So. So, anybody else got a question? Floyd, you done?
Well, I'm trying to figure out here. Okay, if I was to go ahead and put in my instructions with my special deposit, hold my principal until further notice for future return with my interest. So I'd have to discard that.
Unmuted.
And reword it or something. Because I'm going to be putting that special deposit on the total. I'm going to put on that bill for the next 2 years. I'm prepaying that bill for 2 years now. Right? So I'd have to put because I've already told him to hold my principal. What I was going to do is I was going to take your suggestion from the other day, Christian, and see if there was a timestamp on it, then I could put the two together, or one right after the other the same day. But hold my principal until further notice for future return with my interest, with care, or take care of it, or whatever I'm going to say there, and then come along with now take my principal, my special deposit, and apply it to this bill, or whatever I'm saying, or the next 2 years payment. Okay, is that the reason why you're using two separate things? One was the instructions being later. Yeah. Okay, now I understand. And so then that way I can tell them, okay, now that you have my special deposit, I want to take my special deposit and apply it to the payment for the next 2 years, to pay me up for the next 2 years, and then that way that I don't have to mess around paying them monthly, because in 2 years I can renegotiate the contract. Anyway, that's the reason I was doing it that way.
Were you intending to use your indenture as the instruction?
No, these instructions are separate from my indenture. My indenture is what I'm holding in private.
I heard Kristen say, well, you've got two different documents. I'm sitting there, well, wait a minute. So, yeah, you've got two different documents. One is the instruction, the other is the indenture. Is that correct?
Yeah, I've got the instructions that goes with the special deposit. Then I have instructions for the follow-up to the instructions with the special deposit. I can follow that the next day with the instructions with the special deposit.
So were you going to intend to open up a UCC-1 prior to that and add that language in on that document, or were you going to wait until after?
No, what I was trying to do on the UCC-1 is just state that there's a trust form with that there's a trust form under special number blah blah blah, whatever my RA number is. That was all I was going to put in my UCC-1, and then I was going to transfer back up. What are you going to put in UCC-1? I'm gonna put that there's a trust form. I think I was I'm gonna put that there was a trust form. I don't really want to do that.
Yeah, you want to put a trust res or
you want to claim trust res on a one. Yeah. Okay. There's trust res filed under RA number blah blah blah, and then then on the 3, then you put the 3 as a notice that it's been transferred. And they already got it. Right. Okay. And then do my filing in the county on both of those, the UCC-1 and the 3. Making a note. Did you get the simple verbiage we had of 3 lines of claiming and transferring? No, that was, I think I had sent them a Skype request to you Sunday. I think it was Sunday. And I think that was what I was supposed to get from you that Chris had mentioned, I guess.
Yeah, that language, that 3-sentence language that you were talking about, Christian.
Yeah, just that simple 3-sentence. Claim it on a 1 and use that same word that you change the word to transfer on a 3. And really, that's all you have to use. You don't have to use any got a trust or anything. You put too much information in there. I would put something keep it simple. On the UCC-1, what do you put on the UCC-1? It's just the same 3 lines I put on the 3. They're very identical, almost 99%, except for one on the UCC-1 is claiming. On the UCC-3, same verbiage almost, except I transferred changed the word claiming to transfer. Yeah. Okay, I know that I had heard you mention that once before, but I didn't know what the verbiage was. Anybody got that? Excited to?
Now, I don't know if I've got his Skype handle.
It's just Floyd.Hall.
All right, let me look and I'll see if I can find it.
Yeah, that'll give you an example of something simple that you can use. You can use as a basis. Change it around a little bit, that's fine. But what you want to do is just create a notice. I didn't have to notice them that this is even a trust. So the 3 is actually the notice of the transfer, even though it happened, say, 2 weeks ago. Yeah, or 3 weeks ago. It's a public notice for the transfer of the property. It's just a public record. So pick up from there. Okay, so I can just put this is a notice
those three lines, three sentences?
Yeah, Floyd, I can't find you on Skype, though. I put a message out for everybody to send that information to you. Somebody's liable to send it to you next time.
Okay, my Yahoo address is Floyd_Howe@yahoo.com.
Is that how?
HOWE.
Oh, well, then I've got you here. It's just, I've got you right here.
Okay. Yeah. I've been kind of looking at honorary trust, and I know when we talk about the public trust, I wasn't sure if we're talking about honorary trust or not, because the public trust is neither charitable nor private.
You're kind of getting a double up here.
Hello?
If you're not
Sorry, what was
speaking,
that?
just mute out, press star 6. Right, try again.
Yeah, I've been eyeballing honorary trust, and I know when we speak of the public trust, I couldn't help but zero in on honorary trust as neither charitable nor private. And an example of an honorary trust is leaving one's pets as beneficiaries of a trust, or maintaining graves. I couldn't help but make the connection of graves and the straw man of the decedent as a sneaky way of using words to express something under the radar, which basically is what Gilbert is. It's speaking code. And I was just checking to see what your take is on the honorary trust being used as the public trust.
I'm starting to see the actual City Key Trust is nothing more than the United States of America, which is really the statutes and codes, and that is the public trust. And everybody's sworn allegiance, these officials, the subtrust, the Constitution. Now, these are all statutory. So I'm looking at this, really, the statutes and codes is really the public trust. Now, it's made up separate accounts, separate straw man account. It's really through the we the people's straw parties.
Because when you look up honorary in Black's law, it says conferred in recognition of merit or service, but without the attendant rights, powers, or duties. So you kind of link that with honorary trust, which is a trust that's neither charitable nor private. They use our trust fund assets to do things to us that are neither charitable nor private. Aerosol spraying from the sky, disinformation in the educational system, spiritual misguidance in the churches. And,
yeah, but that's due to our misconstruement because we don't execute and express a trust.
Right.
So we're not even claiming a trust. We don't even claim that there's a trust in existence.
Right.
Well, then how can we make a payment from it?
Exactly.
I don't see the necessity for that. I think it's there in existence, and it's right in front of our faces, and I think it's the statutes and codes. That is the public trust. Now, the people swore an allegiance to the Constitution. They have swore allegiance to this Constitution to uphold all these statutes and codes, which is the public trust.
So that
now, when they don't uphold that, then they're in breach of trust, which is really bad faith. They're operating in bad faith.
So now, who
who is the grantor of the public trust?
Well, we the people, set all this into motion. We have a legislature we put into place that legislates these statutes and codes on the public trust that everybody's supposed to live by. And then when we don't, then we get caught up in these statutes and codes. We're not tying in the private assets to pay the debt.
Right. So if we, in Gilbert, it mentions a little bit about disclaiming trustee duties, kind of like what we were talking about earlier as far as sending the IRS some sort of a notice that you quit, your termination of employee status. Would that be considered a...
Get your microphone closer to you. I can barely hear you, please.
Oh, can you hear me now?
Yeah, that's better. Thank you.
Oh,
I'm sorry to interrupt.
No problem. I guess what I'm asking is the ability to disclaim trustee duties under the public trust would I guess be termination of employment, right? Or some sort of a document that would use that language?
Could be. I just threw that out there tonight. I just discovered that today, so.
That's a good idea. I like the sound of that. Well, it's
Did you get that yet?
So I have to type it in. So it's on its way, Floyd.
Oh, okay. I had over 3 lines that says, this is actual and constructive public notice by grantor as owner and holder of all right, title, and interest with, and then I would probably change some things around here maybe a little bit, non-negotiable instrument claim number RA such and such a number US, along with all attachments, proceeds therefrom, are fully claimed, and the records are being held in the private.
Oh, okay.
That's it. That's just public notice. Nothing is mentioned about a trust other than I'm saying by grantor.
Uh-huh. Okay.
Well, that's claimed all right, title, and interest in the non-negotiable instrument claim number RA such and such.
Okay.
Now, I could their non-negotiable special deposit RA number. So then that goes on the 1, and that goes also on the county. Then you can use that on a 3, the very same verbiage almost, except where it says fully claimed, I'm going to put in there now transferred.
Okay. All right.
And the transfer one says basically the same thing. This is actual and constructive public notice by grantor as owner and holder of all right, title, and interest with the non-negotiable instrument claim number RA such and such US, along with all attachments, proceeds therefrom, are hereby fully transferred. The transfer records are being held in the private. And the next paragraph is 1 line. If there is any information regarding this that needs to be gleaned, please contact the grantor at the address below.
Okay.
That's a notice. That's all that goes in the collateral block 4 on the UCC 1 and on the 3, and that's the same thing goes on a county notice that you make up separate. And again, the UCC 1 or the 3 does not get recorded in the county. It's just a notice.
Okay, when you put the notice into the county, you just type that out on a piece of typing paper, right?
Yeah, it's entitled notice. Right across the top. Record that in the county.
Okay. All right. Okay. Should be able to handle that. So then, Chris, you're sending that to me already, huh?
you still on, Chris?
Yeah, I'm in the background. I actually thought I was going to be giving you one that was similar, but it's not the same that Christian was giving you. It's not one and the same.
Oh. Okay.
No, the other one was the safekeeping until return in same time. That was the one I was going to give him, Christian, but you named out something completely other than what I've got. I don't have that document.
All right. Okay. Well, I better write that down then, Christian.
Are you on Skype, Floyd?
Yeah, I'm on. Well, not right now. I'm not.
Which is Skype?
But if you Skype that to me, I can pick it up off of Skype.
How do I find you?
Floyd.how. That's Skype.
I would appreciate a copy of that too, Christian, if you could send it to me.
Perfect. This is Floyd.how.
Okay, spell your first name.
Floyd.
Last name is
Howe.
Howe.
Yeah. I sent you a Skype message Sunday, so you should be able to get my address off of that.
Which one of the 1,000 was it?
Okay.
You know what happens when I get on Skype?
Well, I don't know, but that's what you told me to do, was to request something on Skype.
All right. So it's just Floyd Howe, and that's our Skype name.
Floyd.how.
Okay.
Unmuted.
There's a dot in there?
Yeah, I found it.
Yeah.
That's it, Floyd.how, lowercase.
There's a dot in between the two.
Yeah.
Okay.
But if you just put in Floyd space, how it'll come up.
All right, I sent it to you now, but I'm not on Skype, so I can't get on Skype until afterwards.
Okay, no problem. Thank you.
Hey, Christian.
Yeah, go ahead.
This is Terry.
Okay.
How you doing? I wanted to bring up a different topic. It's reflecting on what we discussed last week with Gamba and Carlos about the transfer and interest in property to a trust.
Right now?
And I just wanted to see if they were online. Maybe they could clarify what they were saying about transferring property. I know Carlos had mentioned a Gorn-St. Germain Act of 1982 where you could actually transfer property into an inter vivos trust. And looking that up, I found some commentaries that discuss that, saying that was possible to actually transfer the legal title to a trust. But as I understand it, if you have a lien currently on a piece of property, that can't be done unless...
You said there were some states that could. He said, like, I think Florida couldn't, and a few others. But
well, he was in California. Carlos is, that is.
Some states wouldn't allow you to do that, I guess, by statute. You couldn't do that if it was in foreclosure. But other states could, I guess.
Well, as a general rule on private trusts, it was my understanding that you couldn't do that, period, if there was a lien currently on the property.
Yeah, I don't know. I'll have to get a hold of them and see what they have to say about that.
Okay. I don't know. Is Gambo on the call tonight? Guess not. But I was just trying to track down that act, and from what I could see in the act itself, it didn't have anything to do with transferring property into an inter vivos trust. Don't know whether that's been repealed or revised or whatever. Didn't want to get into trouble trying to do something like that without fully understanding it, of course.
Right.
Is that the Garza?
Yeah, Gorn St. Germain, 1982. That's an FDIC statute, actually. It was put into place to help the credit unions at the time, but from what I have found in commentaries, it actually contributed to their downfall.
Christian, real quick, can I get Floyd's cell so I can send him these documents? Floyd, are you there?
Yeah, here.
What's your email again?
Floyd_Howe@yahoo.com.
Yeah, Yahoo. Okay, I'll send them right now.
Okay.
I'm emailing them to your email.
Okay, thanks.
All right.
But you're not aware, Christian, of any way you can transfer a property that has a lien on it already into either a private or a statutory trust?
Well, if there's statutory restrictions and you're on the statutory side, yeah, that would hold it up. But if it was a private trust, I don't see there's any restrictions on a private trust.
Even though it has a mortgage already?
I don't believe so. The only trouble is, how would you enforce it without making maybe some kind of public notification at least?
Right. Seemed like you'd have to go in with CCI information and terminate the trust and all that. The original trust.
Do a mirror on the public what they're used to seeing.
Christian,
Happy, go ahead.
could you come in with a 90 and a 91? Get the release of lien just for the interim period, is it 14 days, and then put it into a public trust. And then they can't really put the lien back on now it's in a trust.
I don't know if you could or not. You get public notification that you kicked off the lien temporary, and then, yeah, you probably could slide in through the window there. But I don't know. Yeah, 1991 would be good enough to do that. There are people out there in the land titles, aerial titles, and these are successfully kicking the liens off. Well, what they're doing is they're really not realizing they're really merging the titles.
Yeah. But what he was talking about, transferring the interest in the property with all the additions that you make to it, sweat equity and such, that will probably suffice just as well, because I can imagine you could come up with enough value there that would preclude the mortgage company from wanting to settle that lien first.
Right, that'd be enough for interest to cloud at least.
Right. So maybe that's what he was alluding to, but I kind of got a different take from Carlos. I'd like to get some clarification on what he's doing.
Well, who's going to put that lien on?
Well, the trust would put the lien on the property, the additional properties that you add to it, or the loan that you receive from the trust. To do that work.
Because Jamba has an outside, entity with the lien on it.
Right. The business trust he's talking about.
Yeah, but how do you put the lien on it? I talked to a bunch of bonding companies today about it.
Okay.
So I'm just asking you, how are you going to put the lien on it?
I'm not sure the process to go through that yet.
Yeah. Okay.
Probably be very similar to any other lien.
Christian, can I talk for 1 second?
Go ahead.
Christian, are you familiar with that Garn St. Germain Act thing?
Not a whole lot, no.
Well, all it does is it precludes the lender to be able to, it gets you around them activating the
Did you actually find that in the Act? Because I looked at the Act and I didn't see that stated.
It's in there. I can send it to you if you want. I have like 3 different dissertations on it.
Well, I have the commentaries that claim that, but in the Act itself, I don't see that.
Okay.
Now, is that their interpretation? Is that upheld in court? Don't know.
Okay. Well, I found it in there.
Okay.
But they claim that, right?
Yeah, but listen, Christian.
Yeah.
Years ago, I got a special duty I had to do, and I had to put a bunch of properties together. It's about 20 years ago, and they were Class A office buildings, and they were the biggest ones in the United States. And I had to learn how to find out who owned them. And those guys were always 3 trusts deep. So if you convey the property to a trust, and you do it in intravenous trust, and you do it with the St. Germain Act, my thought was, as soon as you do that, you sell it again to another trust, so you're 2 trusts deep. And the IRS rules, from what I understand, they only go 2 entities deep. So if you sold it to a 3rd trust, and you were 3 trusts deep, nobody would find you. Instead of going with the lien.
Yeah, but again, that's using the trust for an asset protection device. Why don't we just use it as payment? Why don't we just merge it?
Well, just for coverage. I mean, if you do that, then the trustee wouldn't. The trustee's still going to be responsible for that, isn't he?
Yeah.
The trustee is responsible for
out of the obligation. Everybody's trying to run from the obligation. Why don't we just take and grab the obligation, wrestle it to the ground, and get rid of it?
That sounds like fun.
But if, I mean,
Is this gentleman trying to put a lien against his property in order to save it?
to protect it.
Yeah. Oh, all you need to do is do a maritime lien or an appreciable sweat equity lien against the property.
Like a mechanic lien or anything like it.
Mechanic liens are maritime liens supersede all other liens, including banks. It has to be paid off before a bank can foreclose. That's the closest one to a melodial ship and a land patent. An appreciable sweat equity lien is 3rd down the row. That shows that there's a party of interest, that they can't just foreclose on it without compensation to that party for that amount of money. So appreciable sweat equity liens are right there, very close to maritime liens.
Did they say what the lien they were putting on? Did Gamma say what they were putting on?
Yeah, he does mechanics, Christian. And I talked to a couple of bonding companies today about that myself, how they do it. And apparently in most of the states, they say, the bonding companies, in order to get a bond, they say you have to be a general contractor, and you have to have contracts with subcontractors, and they give them to you pretty easy.
Mm-hmm. So the beauty about putting a lien on it yourself is that you don't have to do the negative avertment process. You can just go ahead and put the maritime lien on it and put it on a UCC. The same is true for the appreciable sweat equity lien. Is that if you've got receipts and monies that you've dumped into the property, including the mortgage plus the property tax, plus any improvements and maintenance, all of those things, including your own sweat equity, can be added onto an appreciable sweat equity lien. It's not as solid as a maritime lien, by the way, but it's up there because it shows a party of interest, a real party of interest that has a labor lien against the property.
Now, my idea was to take all that, the payment, of money you owe the bank. So you could just go to the bank and say, hey, look, I've got the money to pay you. I just want you to show me all the paperwork so that I can pay you.
Well, that's what Campbell was saying. He had a standby trust fund set up.
Right.
And then he actually placed a purchase money security interest lien on the property or the sweat equity or loan or what have you. So it sounds like it's working the same way, yes.
So if we all pitched in and we had when we put in X amount of monies for a fund, then each house that we needed to grab, we could just use, just like the banks do. They just take the fund and move it to the next guy, to the next guy, to the next guy, to the next guy.
Right.
They wouldn't need that money to save each other's house by just saying, okay, Judge, here's the monies for the house. Now have them show us, now get, and do the thing what Campbell said, which is have compliance.
Right. But I don't think what we're realizing what we're doing here is,
well, I know we're bringing it up, Christian.
We're just merging titles there. Because what you're just spelling out, what was done, was just exactly under the Black's Law definition of a merger. When the two parties have made a simple contract for any purpose, and afterwards have entered into an identical engagement by deed. Remember, deed is deed of trust. So entered into an identical engagement by deed, the simple contract is merged in the deed and becomes extinct. And this extinction of a lesser in a higher security, like the extinction of the lesser in the greater interest, is called the merger.
So that's a way to accomplish this without having to go into chambers.
Right.
Yeah.
Christian, what about, could you open an escrow with the funds to pay the bank?
I don't see why not. It's just going to sit there until somebody comes up with the...
Make them go in there and subject them to the title insurance, that they'd have to comply.
Right.
Remember, insurance is nothing more than a bond, which is trust.
But I mean the underwriting that the title insurance company that would scrutinize them to, that they wouldn't come up to snuff on.
Be the underwriter yourself.
Yeah, you'd have your own compliance department.
Nothing like cap.
Came under theirs, you're the underwriter.
Okay.
But you have to come up with the investment to place into the fund, it sounds like, which would only be enough to cover one payout, so to speak.
Right, exactly. So we could easily muster that up together.
Well, when we get access to our trust account, that won't be a problem.
Well, I don't think you need to wait that long. What about if there was any equity at all?
Or you take the simple contract.
Huh?
Simple contract. Take the debt title.
Right. And do what?
You're going to merge it with the asset title. And then you entered into an identical engagement by deed. And then you're going to issue a deed of trust, which is your trust receipt. So that, I remember reading someplace, I was trying to find it the other day, and I saw it and found it, and looking, where it said, I believe it said that a deed of trust is the new terminology. The old terminology for the same thing, which was synonymous, was trust receipt. And we've been talking about trust receipt all along down at UCC 1 and the security agreement, being the indenture. And that's a deed of trust. We're just in a simple contract with the asset with the debt, and they're merged, and the deed becomes extinct. The lesser contract becomes extinct.
Can we get can we get some kind of business to, if we're merging the asset title with the debt title and the special deposit is the trust res and the trust receipt, couldn't we use that to somehow acquire value some way, like a standby letter of credit against it, that it would never be used and we only would have to pay like 1.5% or 2%, and we could put that into, we could have somehow have proof in case we had to go to court, where we said we've got the money to pay, and they didn't give us the note to pay.
Yeah, you're mixing up a lot of debtor creditor thinking with what you're saying.
Okay, I'm not trying to do that on purpose, believe me. I'm just trying to.
Oh, I know that.
I don't know if the right word here to say it to trust.
Yeah.
In other words, if you owe $100,000, you put $100,000 into either a bank, a trust account, and you say, "Here, I've got the money for the loan. Here's my compliance. I need the note. I need the, I need it endorsed. I need the identification," and they don't have that, so that the deal doesn't go through. Couldn't you just walk into court with that and say, "Hey, look, I tried to pay it, and they wouldn't. They don't have the thing to pay"?
Well, what is a bond?
Insurance.
Bond
A special deposit.
or special deposit? Okay, so we have our special deposit to be our bond.
Trust receipt is a special deposit. That is your bond. That's your promise. That's your equitable asset.
Equitable asset. Okay. So, if we order them to pay the obligation with the trust res, and they don't do it, then do we still physically have the trust res that we can use for an equitable asset to use for acquiring some kind of note?
You don't have the asset, but you have the certificate of deposit, which acts like the asset. That's recoverable. It could be traded, and that could be used as the bond itself.
The certificate of deposit?
Yes. When you go to the bank and you deposit money in there, you get a certificate of deposit. You can sell that certificate of deposit, and anybody can go into the bank and collect that money that's there.
Well, how do we get the certificate of deposit?
You issue it.
Ah. Okay. I like that. The gentleman that was asking about that St. Germain thing. Oh, yeah.
We're not generating the paperwork ourselves. We're allowing them to generate the paperwork for our authority. No, I'm going to take the authority away from them, and I'm going to generate the paperwork. Therefore, I don't need them.
Yeah, we start conducting business as bankers.
Yes.
Exactly.
We're not counting on that.
And we understand how to negotiate non-negotiable paper on an international venue.
I mean, that's basically what they're doing at huge corporate levels, right, Christian?
Yeah. Back office banking.
Yeah.
Well, I would.
They're grinding the certificate.
I love it.
I've just Googled trust receipt as trustees, and if you do that, you come up with lots of information there about how it was called trust receipt, and then since Article 9 and the UCC came into play, then it became trustees.
So there's confirmation.
Oh yeah, Google's full of it. I mean,
Christian, in the beginning of the call, you were talking about a special account, were you not?
Right, that's where you put your special deposit.
But in all those documents I read off the other night, they use the word special deposit account. Instead of just special account, it's special deposit account. So is the special deposit account the account that they're holding the special deposit in?
Right. Yeah, how they're hiding the understanding is they got layers upon layers of wordsmithing. All these words mean the same thing. And when you finally study it long enough, it's just like it all makes a connection. It's all the same thing. And then you see right through it all. And we need a group of us together with
You're right, Christian.
Because that's where the enforcement is.
Yeah. Well, this group that's already been pretty successful, they've done a couple of these already, and I'm working on an enforcement.
You really understand what they're doing.
Oh, no, you should see. I've seen what they do already. It's amazing. I'm trying to get it together so I can give it to you. But it's...
They're really doing trust, but they're not really understanding that they're doing trust.
No, these guys do. In fact, they were so fortunate to have some accidents occur. What they did is they first went to the bank, and then they went through the regular manager, then the branch manager, then the regional manager. The regional manager somehow leaked to them to go to the title company. The title company somehow leaked to them to go to the the office of comptroller. And the comptroller actually in 3 days sent out a letter to Citibank to tell them to take care of this matter. And then they fell down, so now they're working on the compliance and enforcement back from the Federal Reserve Compliance Department. So there's another possible way to use about a half a dozen different compliances with the enforcement of penalties that might preclude them from going to show up in court.
Yeah, come at them under the breach of trust because they're doing bad faith by not complying.
Okay.
What are they not complying against?
Christian, here's an interesting definition. It's estoppel by deed is a doctrine where rules of evidence prevents a litigant from denying the truth of what was said or done. In the contents of real property transfer, the grantor of a deed, generally the seller of a piece of real property, is estopped, barred from denying the truth of the deed. The doctrine may only be invoked in a suit arising out of deed or involving a particular right arising out of the deed.
And that was deed of estoppel?
Yeah.
Jacob, what were they in breach of? What were they in bad faith of?
What were they? Well, they were in bad faith of
non-compliance with what?
Non-compliance of presentment.
Okay, presentment per what law? What?
For what law? Well, this is from Federal Reserve policy that we were working on.
Okay, and Federal Reserve policy stems from what? Title 12, Title 31.
Sorry?
Probably from Title 12 and Title 31. Thank you.
I can give you the exact one if I look at my notes.
So my point is, if it's a Title 12 and 31, that's statutes and codes. So they're non-compliance with the public trust, statutes and codes. They're in breach of public trust.
In breach of public trust?
Yes. Come at them under breach of trust.
Okay.
What happens when you come at them under trust? Equity assumes that the trustee is guilty and can't prove themselves innocent until they have a receipt of a disbursement. In other words, they have to correct their non-compliance.
Right.
And the strength of the preventing a breach of trust is, and under equity coming at them under trust prevention of making a breach, is equity going to compel you not to breach the trust.
So, in other words, if you
take a stick at them, you come at them under trust and get them under the public trust breach.
on the trust side, if you give them a tendered offer like a trust res, and they fail, aren't they in breach of trust right there?
Yeah, but I would say I would like to get it tied into a statute and code where they would be operating in bad faith by not doing the statute and code.
Here's an
therefore,
idea.
I am for breach of public trust, which is
Yeah.
all colorable. Now I can come at them in public court and get them for a breach of public trust.
Right.
Here's another angle from the UCC, Christian. It says in 9312, it provides that the first to file its financing statement and thereby perfect its security interest has priority. Now, do the banks file financing statements on a mortgage?
No, I don't think they have any UCC as any deposit showings, frankly.
So if we do that on this sort of scenario, then that puts our lien with priority. If we do the filing of it.
Yeah, just a file on the UCC has priority. Yeah, you can show you were first.
Right. Be interesting to check on a particular mortgage to see if they filed the financing statement.
So therefore, a maritime lien or an appreciable equity lien would supersede automatically any claim bank may have.
Exactly. Any kind of lien.
Yep, that's right.
And if it's enough,
that was 9312.
9312. 5A.
5A. Okay.
Jake, you see how we can come at them under public breach of trust?
Yeah.
Because of compliance, if it ties in with banking under Title 12 and 31.
So they on the special deposit that they're doing, they're going in on Title 48.
Or any title breach is a breach of public trust. All you got to do is get a notary to certify something. And that certificate is your certificate of bad faith. And bad faith is a breach of public trust.
Which is the main trust.
Yeah. Silence.
Here's another one in UCC 9, 107B. It talks about a lender may acquire a purchase money security interest in specific collateral where, 1, by making advances or incurring an obligation, or 2, the lender gives value to enable the borrower to acquire rights in or the use of the collateral, and 3, the value is in fact so used.
And under trust, consideration is the confidence.
Confidence, yes.
So when I give, by definition, to voluntarily transfer property to another without compensation, the compensation really is the consideration. The consideration can be the confidence. That's the compensation, the consideration. Confidence. It is the trust. The trust itself.
Christian,
Yeah, please.
you know when we talk about a contract, and we talk about a contract in equity,
Right.
and then the grantor's given his consideration and confidence. The trustee's got his duties as consideration to the grantor and to the beneficiary, and the beneficiary's consideration is receiving the things and also, making sure that there's a trustee appointed and is doing his duty. So, would that be the full sort of foundation of a contract in equity, or is it something other than a trust?
No, I think it's synonymous.
Synonymous, yeah. So when we're looking at a binding contract agreement in contractual law, then we can override that with trust law by nominating the parties or claiming and proving the parties in the trust relationship.
That's distinguishment of the collective contract. That's merger.
Yeah,
You see
and
that?
they're just, sorry?
Yes, merger. definition again, what I just read before. Extinguishment of the simple contract, the lesser contract for the higher, the security, trust, which is the greater interest. That's merger. Do you see it, guys?
So it's a merger of beneficial and legal title
Uh-huh.
by extinguishment. And you're saying that's the lesser contract?
The lesser contract is the debtor-creditor contract.
Muted.
Yep.
Or the higher, the security, which is the trust.
Yep.
But let me read again. When two parties have made a simple contract for any purpose and afterwards have entered into an identical engagement by deed, the simple contract is merged in the deed and becomes extinct. This extinction of a lesser in the higher security, like the extinction of a lesser in the greater interest, is called the merger.
That was in Black's Law 8
Yes.
under extinction.
No, merger.
Oh, merger, I'm sorry.
Merger.
Okay.
So
He's
the
quoting
trust
out of William R. Hanson's Principles of Law of Contracts, 1819.
So the trust is still...
We're on the verge of seeing through the double-plane mirror.
Yep.
It's there. It's just, I'm afraid you're not quite seeing it yet because it's like, you know, I keep on hammering at these old ways to get this debtor-creditor stuff to get out of your mind to where you can start seeing through the mirror. And some of you, I think, are starting to see it.
Christian,
Yeah, Jacob, go ahead.
if you have a refi, and so you're working on this, guys coming at you from a refi loan, and they didn't give you back the note that you refied, does that note have any value?
Well, I don't know if they extinguish the first with the second, kind of like what we're talking about here. But there could be bonds attached to that first.
That's what I'm thinking, that you could use those for payment too.
Yeah, you could, yeah. You'd have to find some way of tracking them down and getting them where you got some kind of title on them, and then you could claim the title and move the title.
Mm-hmm.
Merge it if you want. But you got to create a title. There's one product in existence already, except you just don't know where it's at. Find the title, claim it, and move it. Claim it on a UCC1 and move it on a UCC3. And if you want to merge it, merge it. I can claim titles. I can move titles. Welcome to Moving Titles. Money Banking and Trust by Moving Titles and Commerce. The Moving Titles platform. Look at everything as a title, whether it be a debt, asset, bill, charge, claim, whatever. Claim it instead of abandoning it. Do something with it. Don't just stick it in the ground and bury it. Put it to good use. Start generating some extra coins.
So a claim is just notice, essentially. I notice a claim, UCC1.
That's all it is. Yeah, it's like I go out on a piece of property. I stake 4 corners to the property, go and record it. I just claimed it.
Right.
When you go into the county recorder with a notice, that's your claim.
Just like what they did with the moon.
And airspace.
They're still up there, I'm
They
sure.
counterclaimed it.
Hey, Christian, tell everybody that I just posted a website that gives you about 30 or 40 different law dictionaries, and it includes the 2nd, 6th, and 7th, and Bouvier. It includes like 30 or 40 different law books. I just posted that over there, the site.
What's the name of the site?
hg.org. It goes into all kinds of debtor creditor, goes into criminal communications, ethics, family law. It goes into everything. And it gives several different lyrics, law library. I think you were asking for that a couple weeks ago, weren't you?
Which one?
Lyrics, law library. You were asking for that a couple weeks ago?
No, I think I might have met somebody else.
Yeah. Anyway, I just wanted to mention that I posted it. Gilbert's Law Dictionary. Oh my God, that's what we're looking for right there.
Christian, if they violate the chain of title with proper assignments and proper filling out forms with the FTC and with the state and with security and with international pooling servicing agreements and what have you, isn't there going to be a huge violation with the insurance from the FDIC?
Yeah, why do that? If you could certify a bad faith, if it was in breach on some kind of statute and code, which is the public trust, make a claim, breach of trust.
And the public trust is the U.S.?
It's statutes and codes.
The statutes and codes, okay.
And UCC is a part of that.
Okay.
SEC, FTC, all those agencies that got all those,
Well, the OTS and the COC are the big ones, I have a feeling.
Yeah, well, all 63 million plus statutes and codes. I mean, you can find one that they breached somehow. You can't do today without breaching something today.
Yeah, you can't breathe
Not
without
any
breathing.
And that makes more sense why they have so many of those statutory codes. That's all they are, is just so you can accidentally find one without even looking.
Yeah, the statutes and code is the free invitation to the obligation to perform under the indenture, the statutes and codes.
So if we get into court and they bring in a copy of the note as their valid stance that they can come and foreclose on you, and then the judge, if he makes a judgment, a determination that only a registered security agent should be making, the judge is making a legal securities judgment that looking at a copy of a note that it could be valid. Can't the judge then be held accountable for violating his breach of trust by overstepping his authority into the securities realm?
If you can find some statute or code that he was supposed to uphold, that yes, and get it certified by a notary, and get that notary to generate a certificate of bad faith. You got it. Except how you enforce it. You're going to enforce it under debtor credit, or you're going to enforce it under trust. Because if you do debtor credit, you ain't going to run. If you do probably trust, you're probably coming on it under the right venue.
Yeah, that's absolutely accurate. So when you're trying to work on different aspects that they have violated statutes and codes, those things as you bring them into court, those things are on the public side, and if you're trying to enforce, if your law firm is trust and in equity, then is it much better to leave all those lying dogs alone, or try, because
That's kind of like trying to say, leave those lying dogs alone under the debtor creditor realm. Let's go to the higher law form. Let's get them under equity, under even a statutory version of equity, under a public breach trust. Because it's still colorable, but they got to keep the semblance of the whole thing. Yeah, let go at them under the lower law form. But that's how we've been brainwashed.
Mm-hmm.
That's just public brainwashing.
It's just a layer of protection for them.
Mm-hmm. I mean, really, if we knew that by definition giving was voluntary transfer of property to another without compensation, when somebody asks you to give them something, then why would you give it to them? Unless you wanted to give it to them without compensation.
That follows the principle of conditional acceptance. The honorable approach.
Unless I wanted to gift it to them. But like I said earlier, you keep on saying our willpower is getting them to, in a court of equity, so that equity forces them not to breach the trust.
Right, that's where you say there's no power in you're saying somehow there's no power in preemptively or making sure they don't breach the trust by letting them know beforehand?
Beforehand, right.
Why is that? What's the logic that you say it's more powerful? Because you are taking...
Or you actually cause another damage that's here I can prevent you from even doing that. In other words, I'm getting you to forcing you into doing what you're supposed to be doing and doing what is right.
Right. That's a trust. That's just one of the cardinal characteristics of trust is to point that out when there creates obligation on their part for due diligence.
Mm-hmm.
Okay.
There would be an equitable action under performance, compelled performance. In prevention of breaching of trust. All right, guys, it's getting kind of late.
Thanks a lot, Christian.
Thank you, Christian. It was an interesting evening.
Thanks, Christian.
Shane, you got me on Skype later on?
Yes, I'm on Skype.
Shane.
Yes, I'm going to be on Skype. Do you have a Skype? What's yours?
Christian Moving Title.
One word?
One word.
Thanks, CW. You the man.
Yours is what, Sigma 6?
Yeah, I'm Sigma. No, for my Ask Sigma 6, the number. Moving Titles, Christian Moving Titles. Let's see if I can find you here.
Does anybody need the recorder's manual?
Sure, I'll grab that if you want. If I could get it.
I just sent it.
You got my Skype?
Oh, who's this?
Shane.
Shane. No, I don't have your Skype. Are you part of the NTT group?
Yeah, I guess.
Are you inside? Here, what's your code name, Shane?
Ask Sigma 6.
Ask.
Okay, I found the question. Yeah, ASK, like ask a question. Sigma 6.
Yeah,
guys. See you tomorrow.
Hey,
All
take
right,
care.
good night, guys.
Bye, Christian. Bye, everyone.